Hello, everyone. Today I'm honored to have the opportunity to talk with Professor Brian Bix. He is a professor of law and philosophy at University of Minnesota. His teachings cover areas that include jurisprudence, family law, contract law, and has published academic articles in constitutional law, legal, and moral philosophy. And with that, welcome, Professor Bix, and thank you so much for joining me today.
Well, thank you for the invitation. It's an honor to be here.
Thank you. So, Professor, before we get into the discussion, can you just tell us a little bit about your sort of academic and intellectual journey and what got you interested in legal philosophy and things that it sort of intersected with also philosophy in general?
I've been interested in legal philosophy about as far back in my academic career as I can remember. I took a college freshman first year course with Stanley Paulson at Washington University, and threw us in the deep end. And we were reading, Hart and Kelsen and Finnis and Dworkin, and and I've been doing that sort of work ever since. And it's been a long time.
Well, were there any particular sort of problems or issues that sort of interested you, or was it just a general thing?
All of them, a lot of the, what's the nature of law? What's the nature of justice? What's the proper understanding of contract law, property law, moral responsibility, legal responsibility? Most of the topics, and as we understand, the area of jurisprudence interests me in one level or another.
So I want to start to talk about the expression meaning itself. So we hear judges, legal scholars, even lawyers talk about the meaning of a text. They use this expression. They use the expression, the meaning in context and things of that sort. So the first thing that I want to ask you is, what does that expression itself mean? So what is it that I'm supposed to understand when they mean the text meant this, or this expression means X? What is it? What does that even mean?
The debates in law and legal practice and legal philosophy mirror those in philosophy of language, and I don't, there's no more clear answer in one than another. I mean, I just finished a review of a book by Larry Alexander and Emily Sherwin, and in which they put forward, a standard, highly intentionalist view that meaning isn't necessarily the meaning of the speaker, and not the neutral or hypothetical or idealized, but the actual meanings of actual speakers. And that's controversial, of course. I think when courts talk about meaning, they have a somewhat vague pre-theoretical notion of a sort of folk understanding of meaning. And I don't think they have, occasionally they'll venture out some notion about how much we need to look at the intentions of the drafters and how much we can do without, or how much, though they might understand that ideally we should look at intentions, but there are countervailing considerations, rule of law considerations, considerations of what the reasonable understanding of here is, that law creates additional factors to think about that may not be present if it was just a question of me talking to you, and what did you just mean by that, is different than if I'm the head of the department and I put forward promulgate a norm, and the meaning of the norm may be different than the meaning of when I'm talking to you.
Yeah. So, like, let's go for instance to the topic of like constitutional interpretation. Justice Scalia would sometimes talk about, for example, cruel and unusual punishment, and he would, he was an originalist, and he would sort of mention the example of capital.
A weak-willed originalist, as he himself put it.
Sorry.
He was a weak-willed originalist. There's a debate, a kind of debate between him and Randy Barnett, where Randy Barnett says, "I'm an originalist and I mean it," right? And the difference is, again, there are complications in law. One of the complications in the law is that there are prior decisions. So there may have been an earlier Supreme Court decision that says, cruel and unusual punishment does not exclude capital punishment, does not exclude executions. right? And then let's say in your historical work, you dig deeper and deeper until you at some point you're convinced that the original meaning, the original intention, we'll get to that in a moment, is that executions were cruel and unusual. Right? What do you do when your understanding of original intention or original meaning is different than a Supreme Court decision that is otherwise has precedential value? And Scalia said, originalism must give way. Randy Barnett said, no, the original meaning, intention, whatever, should take priority. Now, the original meaning versus the original intention. Originalism, as Larry Solom and others have pointed out, now have many, many sub-variations, right? The view around the time of Judge Bork's famous article was, what was the intentions of the people who drafted the text? Currently, the more popular view is to focus on what would be the meaning by the relevant audience at the time it was promulgated. We don't need to look at Madison's diaries, the diaries of the constitutional framers. We need to look at cases and law dictionaries written around the time. What would educated lawyers or the general educated public understand by this phrase? Right.
Mm-hmm.
So we move from original intention to sort of original understood meaning.
Right. And how do we, in a procedural sense, how do we figure out what they thought or what they thought the expression sort of meant? They're not here anymore. Their intention, we can't really ask them. So how do we go about finding that out?
Well, there are some resources, right? There are the debates at the Constitutional Convention. There are the letters written for, the public documents written for and against the Federalist and Anti-Federalist papers. We look at the cases that came down from state courts around the same time. We look at the actions of the first Congress, given that many of the people who were in the first Congress were also in the ratification conventions and in the drafting groups. So we have resources. Now, whether the resources are enough to come to a clear and consensus view, perhaps not on many questions, but what originalists would say is there may not always be clear, determinate answers on which everyone would agree, but at least we know where we're starting and we know what the focus should be. And instead of let's just make it up as we go along.
Yes, yeah, that was Scalia's sort of point. He would constantly say that originalism is not perfect, but we do have a lot of answers to a lot of the problems that we're facing. Like even the notion of like free speech, he stated very obviously that that speech did not mean just literal oral talk. It included sort of letters and protesting, and the problem is it just kept expanding and to the point where discussing it, pornography. What does pornography, and I'm like sort of looking at it, what does pornography has to do with speech? From a sort of default point of view, you would think that. But the other thing that comes to my mind, so when a judge faces an ambiguity in a sort of, let's say, constitutional text or legal text, and that leads to two reasonable interpretations. So, like, let's say the unusual, is it harsh and unusual punishment?
Cruel and unusual punishment.
Cruel and unusual punishment. There is an ambiguity there. So regarding the conjunction, so it could be a punishment that is unusual and cruel, or unusual or just cruel. So how does a judge go about resolving that? Because it's a huge. It could result to sort of very different results, depending on how you interpret it.
So I mean, if you are an originalist, right, the first thing you do is try to figure out if that's a distinctive phrase. Where did they get it from? Was there was this a phrase that was often used? How was it understood at the time? There is in the modern sale of goods law in the United States a commentary that certain provisions will not become part of the of a contract under certain context if the provision was surprising and burdensome. And this is surprising. Was it surprising or burdensome? Surprising and burdensome, and the courts disagree, and so on. So, even when you don't have significant historical research, you can get into these sorts of quandaries. How do the courts decide? If they don't get the resources, if they don't find the answers they want by looking at the historical record of the old cases, they might ask, what is more consistent with the spirit and the purpose of the enactment? What were they trying to do here, right? Another thing they might do is say, those who aren't originalists say, no, what's going on in the Constitution is that judges are told to apply moral standards, right? The Constitution uses general language, cruel and unusual punishment, due process, equal protection. And like other general language, like if I tell you to go out and find me a good piece of literature, right? That's not precise. It's delegating to you to make the judgment and finding the best piece of literature you can, right? So what moral values instantiated by the prohibition on cruel and unusual punishment? And which is it more consistent to say, well, it's certainly cruel, but it's not that unusual, so it's okay? Or is it better to say cruel or, this is unusual, but it's not the least bit cruel, right? That doesn't, will make you turn around in a circle 9 times. Well, no one's thought of that before, but it's not particularly cruel, right? What kind of standard best instantiates our best moral understanding of the quality, the virtue, the objective, the moral objective that's involved in the text at question?
Right, and isn't that a very sort of speculative inferential process that is easily sort of defeasible? What I mean, like you could make a very good opposite case for whatever the judge may come up with, and that's one side of it, and the other.
That's why they pay judges and lawyers the big money, right? Yes, of course.
Yeah.
There's almost nothing we do of any importance that you can't come up with a decent argument the other way, and that comes up with the originalists as well. The gun control cases. There were big, large historical briefs on both sides of it. So I'm not sure that the fact that this is I teach at a law school. Part of my appointment is at the law school, and what we do is with every case we ask students, well, what's the argument on one side? What's the argument on the other? If there isn't a decent argument on both sides, we don't teach that case, right? So I don't know what follows from the fact that yes, there might be a decent argument on both sides, and reasonable people will disagree. That's throughout law, morality, politics.
The leading conclusion that even Scalia would sometimes point to, so he would say sometimes, like he would say that there are some issues that a judge isn't necessarily in a better position to find out, like for example regarding the current moral standards or the standards of decency of our time. Since it is a democracy, it should be a bottom-up process. Let the people decide what they want through voting, even though it's an interpretive issue. They should decide rather than the judge. Is the judge necessarily in a better position to decide those things?
I think that's a perfectly reasonable concern. And at any given time, especially in the United States, where judicial appointments tend to be very political, half the country or so is not happy with what the judges are doing. I think it's a perfectly reasonable concern. That said, if you want to apply a constitution, and the Constitution is clearly telling judges to apply their best understanding of moral standards, I'm not sure what the alternative. I mean, I guess one commentator, a couple of commentators said, well, the way around this is to say that if you're supposed to apply equal protection or due process, then you should apply a conventional understanding, right? You should do your best to mimic what 51% of the population would think that equality requires, or justice requires, or negation of cruelty requires. And that would be one way to somehow take it out of the hands of judges. Maybe. I mean, I think that leads to in some ways, to overstate it slightly, the worst of all possible worlds. Why be bound by a constitution which then throws you to a conventional understanding of moral standards? At that point, I would just say, you might as well, do like Britain does and throw the whole thing into the democratic process.
Yeah, because it's sometimes it leads to, like, that's what critical theorists say, that it's just politics, it's just ideology, that's all. And for someone, especially lawyers, that just is very abhorrent. They can't really tolerate that. But like the ones that I would see, and I think even in your papers in which you were discussing Susan Hack's, she's a great writer, Susan Hack's work, and you were talking about sort of, you didn't explicitly mention a sort of critical legal theorists, but you were, I think, dismissive of their sort of arguments. Am I right about that?
Dismissive of all their arguments. Some of my best friends are crits.
No,
I was taught by CLS scholars, and 100 years ago when I was a law student. I have great respect for them, and I continue to believe that their work should be read, and that it raises challenges that are not easy to respond to. I mean, on just these sorts of issues, Sanford Levinson has a very good sort of critical CLS style critique of the indeterminacy of constitutional language, and I'm not sure there has been a fully adequate response to his challenge. So I certainly do not mean to be dismissive to them at all.
Yeah, I'm talking about most like the sort of the radical arguments where, like, all, for example, legal cases are indeterminate, or where
the most radical forms of legal indeterminacy I think are hard to sustain. Sort of the standard response to some indeterminacy arguments, some deconstruction arguments is that you just made a claim in English that you think that appears to have a meaning, and you intended to have a meaning, and if which seems inconsistent with the notion that no text has any indeterminate meaning ever.
Yeah, especially if someone, like, really, let's say, judge believes in Derrida's doctrine that there's an infinite number of interpretations, and it's all fair game. One can sort of imagine how you could be so cynical, and indeed many are, regarding the legal system. You just
there's plenty of cynicism to go around. You don't need to be believe in the radical indeterminacy of language or the radical indeterminacy of normative standards to find reason to be cynical about the law.
But
so those positions, I said, tend to be self-refuting, but there's still plenty of room for indeterminacy and plenty of room for cynicism and worry.
Right. And do you think that's something that is embedded in the way we do law? So you think you've said it's not about language necessarily. You can just change the expression and you still have the same problems. But since there are certain principles that we do believe in, so there is democracy. Now, obviously, there are several different formulations of it, and what does it entail? But we just avoid that for a second. And there is also the view that we don't want grave injustice to occur, because we're talking about people's lives here, and delegating power to authorities could have some grave consequences, as we see in totalitarian regimes, where vagueness is exploited heavily. And me being here in the Middle East is something that I'm very in touch with, and I see it being done very it's the problem with it is like stealth authoritarianism, because it's embedded in law, and the expression that you use are so open-ended that you could deploy it for wherever suits your purpose. And that. So how would you think of that? Or what would you?
So I'm going to answer this problem in 30 seconds or less. I mean, going back to Aristotle, at least, right? It was understood that when you put standards into codified legal rules, or codified moral rules for that matter, there will be circumstances where the application of the rule to the facts will lead to a result that appears to be immoral, unjust, absurd, and so on. And so you can find, going back to Aristotle and through to the present day, concern that there should be some sort of counterbalance. There should be equity. There should be an ability of the judge to do justice, to do fairness, to ignore the law where the law is at its most unjust or unintentionally absurd or just doesn't apply to these facts, right? And then, though, the judge who is claiming to do justice, claiming to do equity, may not, in your particular perspective, be doing equity. They may be actually causing injustice to increase. They may be in favor of the powerful over the powerless, the unjust over the just. They may be stupid. They may be short-sighted. They may be corrupt. Even judges who aren't doing equity, who are simply purporting to apply the law, may be incompetent, corrupt, unjust. But to have a working legal system, what the judge says is law, right?
Yes.
At least for the moment.
Yeah.
Well, we then try to create safeguards to that. We'll have an appellate process. We'll have an appellate court that will correct the errors of the less competent or the more corrupt. But those judges can be incompetent or corrupt. We'll have a second level of appeals, but those judges, there are many people in the United States who aren't particularly happy with what the our Supreme Court has been doing about abortion, or to a lesser extent about equality in religion and religious exemptions. But there are other people in the country who weren't happy about what the previous Supreme Court was doing. I mean, again,
Yeah.
right? What the complication is that you can have legal standards, but the legal standards won't always apply well. You can have legal standards, but you also need to respect what courts do, and sometimes what courts do may arguably be in variation of what the legal standards said, right? And that's where, getting back to the thing we talked about prior to the beginning of the recording, right? Where Justice Scalia said, I'm a weak-willed originalist. I believe that original meaning, original intention may have to give way before precedent. Well, the problem with law is that you have the legal standards on one hand. Law is what the legislature says it is. You have the court decisions on the other hand. Law is what the courts say it is, and sometimes those are in tension. And sometimes either the courts or the legislature are passing laws or passing decisions that are unjust. These are problems that go back as far as people have been thinking about them.
And what is this current sort of consensus in America regarding the whole notion of justice? Like, is it?
There's never been a consensus in the United States.
In the Supreme Court.
There's never been a consensus in the United States. There's never been a consensus in any other country I'm aware of about what justice requires, or about the justice of what the highest court has said. I mean, there is a certain theme or value in this country, as there are in most countries, that we need to follow the law and we need to do what the court tells us to do. But there's always been a feeling throughout our history that sometimes the court gets it wrong. Abraham Lincoln responded to one decision by the Supreme Court by ignoring it. Andrew Jackson responded to what was a much more just decision by a later Supreme Court by ignoring it. There are many people in this country aren't happy about the recent abortion decisions, and different people who are unhappy about what the court said only a few years back about same-sex marriage, or what the court said a few years before that about the presidential election between Bush and Gore. There's never been a consensus. I think, as I understand the opinion polls, people's respect by the Supreme Court right now is about as low as it's been for a very long time. But I think there's always been, some people didn't like what they were doing about desegregation, and other people didn't like what they were doing prior to that about segregation, right?
Yeah.
I don't know how it is where you are, but there's no general and ongoing happiness with the law. There's always some portion of the population that's not happy about either what the legislature is doing, what the Supreme Court is doing, or both.
Yeah, sometimes, as I've observed, it has to do with the populace not getting the kind of results that they want, regardless of what the law requires, regardless of what the text says. So they would like the judge to interpret the text in a particular way to suit suit their sort of purposes, their moral beliefs, their political beliefs, and so forth. Like in my, like even Justice Scalia, I think my default view would be that, you know, it should be a pure, maybe not pure, it's most, for the most part, it should be a garbage in, garbage out system. You get an input and an output, and that the judge serves that function in the middle. And
Well,
obviously,
Chief Justice Roberts said we're simply umpires calling balls and strikes. But whether we're talking about Roberts or Scalia or more liberal justices like Marshall and Brennan, you can always find decisions where their calling balls and strikes doesn't look very, you know, it seems clearly like their political priors, their moral priors have, you know, like any other, like almost every other human being, cause them to not see things, or to see, you know, not see things that are there, or to see things that aren't there.
right.
You know,
Mhm.
I don't know that any of us would have been or would be perfect as judges, but you know, I don't see any reason to assume that Scalia and Roberts are any better than Marshall or Brennan about just calling them like they see them, as the baseball expression goes.
Right. So I want to move on now to the problem of vagueness, particularly in legal texts and how they're applied. So we have established that we will face indeterminate cases, and in the United States law we do have a doctrine called the void for vagueness
No,
doctrine.
the constitutional doctrine, which is very rarely applied.
Right, but it is applied. I don't remember the exact case, but I've seen it being
Yeah, no,
applied
there are
several
cases,
times.
but there's remarkably few, and lots of people raise the void for vagueness
Yeah.
argument in places where, you know, I think it's reasonable. You know, some, but courts shy away from that, applying it to invalidate legislation.
Right. So isn't there a constitutional protection where it says that the text shouldn't be vague, and that the, you know, citizens should be allowed to, you know, should be able to sort of follow the guidelines, and it should be in a clear language. Isn't that a constitutional?
It's not a constitutional text. It is a constitutional doctrine created by the courts. Now, as I said, to use a doctrine to entirely invalidate a statute or standard is very rare. There is another doctrine whose level of application, it depends who you talk to about it, called the doctrine of lenity, lenity, which in criminal law matters, many courts have said that in a criminal law matter, if in case of ambiguity, we will construe the statute narrowly because of the general principle of due process, the general principle of liberty. But law is always vague. And we tolerate quite a bit of vagueness, depending on how you understand vagueness. For our purposes, just, you know, the application of a term is indeterminate, especially at the boundaries, right?
Mm-hmm.
Most law is vague. You know, we do have statutes that say you must, you know, the constitutional provision, you must be 35 years of age to be president of the United States. That's a relatively determinate and relatively silly requirement, but it's determinate.
Yes.
But most things say things like often say you have to act in a reasonable manner. You know, your liability for an accident will occur if you acted unreasonably. Contract law, many of our contract standards involve, was the action reasonable given the standard? So there's a lot of vagueness. There's a lot of indeterminacy, and there are standards for, you know, sometimes in contract law, as in criminal law, construing it more narrowly and in favor of the party that against whom it's being applied. But we tolerate a great deal of indeterminacy.
Mhm. But as far as I know, I think there is a threshold. Like you cannot, there is a certain limit. You cannot put it. It can be extreme vague to the point that just could lead to arbitrary sort of discrimination, things of that sort. There is a threshold, I'm guessing. And I think there
Yes
is.
and no. I mean, there is a threshold. I mean, there are, as I said, there have been a handful of cases, a mere handful of cases, where the Supreme Court has invalidated something like, you know, standards like you can't be a gangster. right? There actually was a statute somewhere that you cannot be a gangster, right? That was considered way too vague. But there are plenty of standards that are awfully vague and leave a great deal of room for discretion and discrimination, right? Reasonable grounds for search and seizure, reasonable grounds for stopping a car, right? That's very vague, even at the most generous and charitable understanding of the phrase, and leaves a great deal of room for conscious or unconscious discriminatory application.
So don't you think the expression reasonable due to its subjectivity, is problematic? So just to give you a random example, so when I was in the UK, when I was in the train station, in the sort of tubes is the train stations. So we would hear sometimes this announcement, and it would go, if you see something that doesn't look right, please report it to the authorities. And I thought about playing with that, a little, for just to see what sort of a result would I get. But I think you could see what would happen if such a text would be present in our legal documents, and a lot of people reasonably, object to it, because it virtually could be anything, and they could, arrest or report anyone just on that grounds.
Yeah, but as I said, our legal standards are full of, did you have reasonable grounds to make that stop? Now, for the search, and if it's tested in court, the police officer will have to come in and say, well, precisely what I saw was this, that, and the other, and some grounds will be rejected. And if the police officer says, well, it just didn't feel right to me, that won't be good enough. But it still leaves a vast amount of discretion. And if you look at the actual cases, it's very rare for the stop or for the search to be invalidated. And the set of facts, the set of observations that are upheld under challenge give a great range of potential behaviors and potential responses. So you may not be. I mean, one response is I'm not sure how to get rid of all this subjectivity. So, there are many people who are not entirely happy with how the police operate in this country. And the many occasions that justify the belief as there's a great deal of racism, sexism, Islamophobia, homophobia, anti-Semitism, et cetera, in the way the police operate in many places at many times. But if you were actually going to try to say, okay, one way to respond to that is we're going to get rid of their subjectivity and discretion, good luck, right? Good luck in coming up with a workable standard for how police operating in good faith, can act in a way that's functional, that doesn't also give them a great deal of discretion.
Well, honestly, that's what got me interested. Because maybe I was like completely and I am naive and foolish to some extent. That I thought maybe I should give it a shot. Maybe we could come up with something. I even hypothetically tried to come up with something better.
I was, in a completely different area. I was on a committee coming up with a proposed uniform law regarding marital and premarital agreements. Nothing to do with the criminal law, but I mean, the problem of drafting things so that the standards, don't lead to too many absurd, unjust, contrary to purpose outcomes is very, very hard. And maybe I'm being naive or cynical in the other direction. Maybe there is a way. Maybe there is a standard, and maybe I'm giving up on it too soon. And maybe this would be a good project. I mean, say you're looking for a project, this would be a great project. I mean, my starting point is suspicion that it can't be done, but I'm happy to be proved wrong.
Yeah, to just as a random example, like sometimes linguistics or even philosophy of language could inform someone. Like for instance, I don't know if you know about the de re and the de dicto distinction. Yeah. So I think it was about regarding the Rwandan genocide. I think it was genocide done in West Africa, and there was, I think, a problem there in the sense that they were the judges were exclusively just reading a de re distinction, their interpretation, and they forgot that there is a de dicto interpretation of it. So
Yeah, no, that comes up from time to time. The sort of the opposite side of this is artificial intelligence use in policing, where they say we're gonna send police where where there statistically has been higher crime in the past. Well, that's been found to have its own problems, because often what's thrown, you say garbage in, garbage out, what's thrown into the AI may itself have been, highly racist, highly subjective, highly discriminatory. Same sort of issue when we try to deal with legal interpretation through corpus linguistics. Throwing everything into the computer turns out to have, more complications than many people thought. So, there may be ways around, whether it's through philosophy language, whether it's through artificial intelligence, whether it's through computer modeling, ways around these sorts of problems, but sometimes the problems sneak back in.
Yeah, so one could have a discriminatory or a so-called sort of racist intentions inside of him, but the difference is when you're talking about a purely garbage in, garbage out system, the inputs are explicit, and in a sort of in a democratic society, they should be accessible in principle, at least.
Well, they can be, but the point is sometimes the discrimination is hidden. So you can say, yes, well, it's an entirely objective system. We're throwing our police resources in those areas of the city that have had the highest crime rate.
Okay.
Well, it may turn out that, why certain parts of, let's say, New Haven, Connecticut have higher crime than other parts of New Haven, Connecticut, is because the police were more willing to look for drugs, in minority area street drugs than they were to, let's say, go up into the Yale University dormitories where there's, as much, if not more, drug use, right? So objectively, yes, there was more arrests in one place than another, but that may have in turn reflected discrimination in how policing occurred. And so it can be as transparent as you like, but you have to dig a little to find that there is in fact discrimination going into these seemingly otherwise objective numbers.
So going back to the so I mentioned that example because I wanted to talk about the role of philosophy of language and of linguistics. So I think you were trained as a lawyer, and you served as a clerk for several justices. Am I right about that?
I've worked for a number of judges, not a number of justices. Justices usually refers to the highest court.
Yeah, sorry. Yeah. So, for instance, if you were to use if you have like a legal case and you're about to use a theory or sort of the latest theory we know in linguistics or philosophy of language to highlight a new interpretation of a particular text, do you think, so in that sense, you have a good case on your hand because because you can say, okay, I have an expert sort of view on this text, and these are the linguists, these are the experts on my side, just like the role that a psychiatrist could play in a case. You have here a linguist that could do the same.
Well, I mean, I think the example you gave earlier, the de re de dicto, is on one hand a very good example where philosophers of language can help clarify a problem that sometimes gets past the courts. I've seen a handful of cases where it's been pointed out the judges seem to be tripping over themselves about that. It's a good example and a bad example. It's a good example in that I think philosophy of language clearly explained would have been helpful. It's a bad example in that it's a relative handful of cases, and Grice or Quine to the rescue is not going to happen very often. I mean, we can make some basic distinctions about text meaning, sentence meaning versus speaker meaning. We can talk about implicatures, but oftentimes the legal materials already have that, even if not under those names. These aren't things, these are things that the courts, at least at times, understand. You have to remember that some judges are lazy, but more judges are just extremely busy, and so they don't They can't devote the time to each case that we might devote to a chapter of our dissertations. All right. So
Yes.
sometimes they may miss a nuance of speaker meaning versus sentence meaning, but it's not that they couldn't understand it or that other courts haven't seen it, but they're just working too quickly.
Yeah, yeah. Yeah, that's a good point, and because the cognitive resources are limited, not just with the judges, even with the legislatures, with the original founders of the Constitution.
Yeah.
The knowledge, they're not omniscient beings, so we can't interpret their text as a sort of it's a sort of a symbol standing for an object, and it's a sort of direct correlation. They made mistakes. Their knowledge was not complete. So there is an argument for sort of a more sort of progressive
I
kind
mean,
of
so
view.
a standard example is equal protection of the 14th Amendment of the U.S. Constitution, clearly meant to respond to this, slavery and other severe racial discrimination of its time. So move ahead 100 years, 100+ years, and now the question is going to come before the Supreme Court again in the coming months. What does this tell us about affirmative action, about positive discrimination in favor of racial groups that face historical oppression? I mean, the short answer is not a darn thing, because it wasn't the least bit in the minds. The people who wrote it couldn't possibly. It was beyond their imagination. What should we do at a time when more favorable treatment is offered? But that's a question the court has decided in the past and is going to be revisiting, and under the current conservative court, one can sort of predict which way it's going to go. But in any event, the notion that lawmakers don't have in their mind, or at least not clearly in their mind, not fully debated, not fully thought through, issues that may come up in 5 years, 10 years, or 100 years. And what do we do about that?
Yeah. What do we do?
I'm sorry, I don't have an answer for you handy. But I mean, these are the debates that continue. That that we haven't resolved, and philosophy of language is not going to resolve for us, and it's some combination of moral and political philosophy.
Well, so just the reason why I still think that philosophy, maybe philosophy in general can play a substantial role. For instance, I think that some of the concepts that are used may be confused. So, for instance, you might have mentioned the notion of like racial discrimination, and I'll sort of point out and attack the concept of race in itself, because I know it's highly indeterminate and it's not even completely biologically grounded the way we classify race: white, black, and
Socially constructed as much as you like.
yeah.
And absolutely right. And therefore what?
Well, for instance, if you're, for example, using the concept of race as a criteria for, I don't know, if you're going, for example, even back to the times of apartheid in South Africa, where blacks couldn't be with whites and so forth. Like even then, you can. I mean, obviously, it was a very unjust system. But if someone could make it obvious to the general public how incoherent and inconsistent the whole notion of race is, and actually maybe that race doesn't actually exist, is a complete myth, and here's why. Here's the biology that we need. That's what I'm sort of concerned with sometimes. That it seems, man, this whole concept of
Look,
being,
if you can overcome racial ideas, it's a wonderful thing, and I recommend it. But in the meantime, we have a society in which people conventionally or ignorantly think of one another and themselves in racial terms. Okay, and
yeah.
and we have to respond to the reality in which we currently live, and not just say, hey, race is socially constructed, or the Constitution says we shouldn't discriminate on the basis of the race, so we're going to pretend it isn't there. I'm not sure that's the morally optimal response.
Yeah, the problem is there's a conflict even between people, between sort of an essentialist view of race and a socially constructed view of race. Because, you know,
Yeah.
someone like even me, I don't know what race I belong to. They're part of, like, my grandmother is like
No,
from this
I'm
side, that
happy.
side,
I'm
and
happy to accept.
yeah,
Between us, let's
yeah,
accept that race essentially doesn't exist. It's
yeah,
socially constructed. Genetically, there's more variation within race as there is across races.
yeah,
I think that's all entirely true. But
yeah.
the fact remains that in the United States, I can't speak for other countries, so I've heard about other countries, right?
Mm,
In the United States, people still self-define and define others in terms of race. They make decisions, political, social, and employment decisions on the basis of race. What should we do
mm,
about that? Right?
mm,
Should we, how should we respond to the historical treatment of the group of people who are defined or self-defined in certain ways? Just to tell them, hey, it was all a myth, so ignore it, or we can ignore it too. I,
mm,
I'm just not sure that this works, or at least
mm,
it's not a quick answer. I would need look. I understand the argument that, for example, if we ever hope to get to a post-racial society, the argument is we need to start now, right? You're not gonna racial quota your way to a post-racial society. I understand that argument, and it has some
mm,
force. But the notion that, hey, I've proven to the satisfaction that race is socially constructed, therefore, we don't have to deal with it again, is
mm.
ignoring the reality all around me, if not necessarily all around you.
Yeah, well, yeah, one could sort of change how one views the problem. Like there is a group-based discrimination since the start of human civilization, and it may not be necessarily unrational completely. There is sometimes there's a good grounds for that. You know, regardless, just group-based discrimination. People discriminate between based on
Yeah,
age, competence, and so forth,
yeah.
and endlessly. Some of them are undesirable, some might be desirable. The I think when you're having, you know, using like just to go for example to use the example of, like, you know, witches. Certain people before did believe that certain people were witches, and maybe they believed that they were witches themselves, and, you know, consequently burned them, and, you know, punish them, so forth. But that doesn't necessarily mean that witches do actually exist. And
But let's say there's an identifiable group of people who were persecuted as witches, right?
mhm,
Um, let's say we create legislation that says anyone who was persecuted as a witch or descended from someone who was persecuted as a witch has a right to favorable treatment in admission to the university.
yeah.
I see nothing wrong with that. And I certainly don't believe that witches exist, but
Yeah.
I mean, same thing with, the treatment of lower caste people in India, right? I don't think there's any, there's a biological grounding. They're the children of other people from lower class, but I don't think there's any biological basis for treating people differently because they come from this quote unquote caste rather than another quote unquote caste. But
Mhm.
it's still a social reality that there's been this injustice and that this injustice has ongoing effects.
Hmm. Hmm. So for someone, and I think I'm, like, getting near to the end here. So for someone who isn't like trained,
There's a limit to how much anyone can take. Usually my students not off long before now.
no, I'm usually I can talk for like 2, 3 hours. I have a very
That's
open,
impressive.
yeah. I don't get tired really from, like, I get it's my
Maybe doctoral work is in your future.
well, it's
When I was an undergraduate, I had someone who taught set theory for 3 hours once a week. I've tried a 3 hour class. It's beyond me.
it could be tiring if just one person is talking, then yeah, it could be tiring. But when it's a dialogic process, it's actually quite enjoyable, and they're both.
Remember, eventually they killed Socrates. They could only take so much dialogue.
Well, believe it or not, that's one of the reasons why even what got me even interested in, like law and things of that sort. Because I remember what they accused him of. Like, how did you, like, they said that he was
Subverting the
misguiding.
youth. He
Yeah,
was undermining the gods and
yeah,
subverting the youth, and he was.
subverting the youth, and, you know,
And he was generally making himself a nuisance, which he was. But I, don't think that adequate. So I think he, in some ways, fit the description, but I don't think it was an adequate grounds for killing him.
mhm.
Um, and thus we go into the Crito.
Hmm. Yeah, well, he was for quite often as you know, he's just basically questioning what your beliefs are, and he will question up to the point where you have to admit your own ignorance, and he might leave you with nothing. He might not even tell you what the answer is.
There were public forums where these things were debated. Socrates did not take part of these public forums. He and his group of followers would sit off on the side, wait for important people to leave the debates, and then interrogate them and show that their views were nonsensical. So again, Socrates, why don't you come debate in public with the rest of us? Why are you just waylaying me with your group of young rich kids?
Mm-hmm. Yeah, I think, a lot of like sort of young guys, whether they are in philosophy or, studying logic or mathematics, are getting quite cynical about law and, even like legal language. Because, especially if you're going like, if you're working exclusively, let's say, in like propositional logic, and you're working and everything that you need is explicit. Here you are, you have these axioms, and there are these theorems that you derive from these axioms, and this inferential, everything is deductive and clear. And then, okay, you're obviously a political person, you have a political life, you have to follow these rules, and they also apply to you. You want to be a member of society, and you want to contribute positively. You don't want to be cynical, you don't want to be, expressing pessimism. But you're facing with these so-called guidelines that are or these norms that are supposed to guide your behavior, but you don't know how they guide you. You don't really know how to approach them. So this is just like a word of advice for us young kids who don't want to go cynical.
Okay, so yes, law is not logic and math.
Yes.
But I think the way to start thinking about this is that morality is not logic and math either. I mean, this is one of the insights of the modern virtue ethics theorists like Rosalind Hursthouse and others, right? Morality isn't math either, and law is applied morality, right? It's applied morality, with an eye to politics, with an eye to practicality, with the eye to the psychology of how to deal with, in sort of John Rawls's sense, a large collection of people who don't always agree on the comprehensive theory of the good, right? So yeah, I think there's a lot to be cynical about in the way that law is practiced in many places. But even if you want to think about how law would be practiced in an ideal place and people acting in good faith, it's complicated, right? The same way morality is complicated. It involves judgment, a practical judgment. What's the Greek term phronesis? I think a certain form of judgment that only comes with years of experience, right? The developing of the virtues, right? Those don't all map onto law, but it shows why in some ways, why you shouldn't expect law to be easy and objective in any simple way. That we need to come up with standards to be applied by other people, including people in the future, to other groups, to offer practical guidance, to empower people who need to be empowered, to restrain people who need to be restrained. It's hard.
And do you think, so obviously we do have different legal systems, and do you think the current the way the system is set up, so Scalia would emphasize on this point. He would say that the reason why we are so free is because we have the separation of powers, and regardless of whether you think this is true or false, the question so we talked about how powers and delegation of power could result in discriminatory behaviors and corruption, things of that sort. Do you think we can deploy a particular legal system that could restrict it, and is like a sort of like in terms of hierarchy, what would the best system would look like?
I see, that's an enormous question. I mean, my short answer is that while I don't think that the United States has the best of all possible systems, you can look around the world, it's not like Italy's system is working spectacularly either. Um, I think a lot, this is sort of a hackneyed answer, but I think a lot depends on the population, right? When the population is as divided, as partisan, as suspicious, as driven by social media as the United States population is, I'm not sure there's any system that would work well. Um, and how we get from where we are now to a place where we're more civic minded, more willing to compromise, more willing to dialogue, more willing to trust. I don't know. Maybe you can tell me. I think it's crucial, but I don't know how we're going to get there from here.
I'm trying to find some hope, really, to get something positive.
Don't talk to old people. Old people tend to be cynical and resigned.
Well, they often do have some insight that we don't have. Like young people often do have this sort of revolutionary sort of temperament. They want to change the world,
Sure,
change things,
sure,
things of
sure.
that sort. Well, and that's how I was when I first started. But as you got more mature, and I did become more and more maybe cynical a little bit. When I don't know if that's the right word for it, but I think maybe it's a mixture of like cynicism because you're trying to overcome this problem and it's just so complicated and you don't know what to do with it. You don't know who to consult and
Yeah, well, it's unlikely that the answer is simple.
yeah.
I'll go that far.
Yeah. Unfortunately, we do have like a lot of these sort of reductivist answers these days that is all encompassing answer. Oh, it's just all,
Yeah,
about politics or like especially in America right now where political polarization is its worst probably because I do remember a time where it didn't used to be that way.
no,
Yeah, and even you can also attest to it. With people like you can have people who are like sort of Republicans but lean a little bit more to the Democratic side and vice versa. But now it's you're either with us or against us, either this or that.
well, the Ted Kennedy used to be able to work across the aisle with some of the most racist, bigoted people and still find some way to work with them and compromise and get something done. Now, you can lose in a primary election because you're accused by your opponent of having worked with the other side, and if that's the basis for losing an election, if there's one thing politicians learn quickly, it's that not to do whatever it is that causes you to lose an election, right? If supporting gun control will lose you the election, if compromising with the other side will lose you the election, you won't do it. It's a simple Darwinian process, and if you do it, you're not going to be around to worry about. So, yeah, I mean, right now the feedback loop is all the wrong way.
So this is the first time I'm talking to a legal scholar about this topic, and it's concerning the principle of freedom of speech. So I'm not going to talk about its virtues or whether it's good or bad. I just want to talk about how one should understand it in principle. Like how should we try to understand that principle?
Now it's another enormous topic, and I don't even pretend to be an expert on free speech. I defer to your next interview.
Yeah, I have read quite a bit on it, and yeah, there isn't any. Well,
there's plenty of people who've written quite a bit on it
yeah.
recently, and I suggest you interview them on that.
Well, yeah, well, even someone who's you've studied law and you just when you're looking at such an expression, freedom of speech, how how do you come and understand the notion of speech? Like, what are the principles that you draw? Like you yourself, what are the principles that you draw upon to understand that notion? Is it just let's go back to that original time how they understood it, or is it more than that, or?
Well, it requires constructing some notion of what the purpose is. Is the purpose about political understanding and wanting people to be able to get as much information as possible in as unconstrained a manner as possible so they can be educated citizens and voters? Or is it about the liberty of the individual to find his or her own path towards a good life as they understand it? If whatever you understand the objective to be, that'll color how you interpret and apply the doctrine, especially outside of its core area, right? What does it mean about libel law? What does it mean about pornography? What does it mean about censoring religious views? My inclinations tend to be more along the line of John Stuart Mill from On Liberty, but there are plenty of people who have a very different understanding of the First Amendment.
Yeah, the problem that follows that is that you have this very ad hoc view of how this principle is applied. Like someone comes along and just expands it enormously, becomes an absolutionist, and then someone else comes and just narrows it and just includes these sort of restrictions that are vague in themselves to suit their own, agenda and purpose.
Well, one problem is that in law, at least the American legal system, we have an adversarial system. If you hire me as your lawyer, and I'm available at an unreasonable rate, I'm going to try to win for you, and I'm going to put forward any argument that I think will help you win, and the other side will put forward whatever argument they think will lead that side to win, and it's left to commentators and occasionally Supreme Court justices to try to take a big picture view as opposed to whatever view will be in my short-term benefit.
So do what the sophists used to do, just try to create the best possible argument for your case, regardless of what the truth may
No.
be.
If you're a lawyer, yes. If you're a lawyer, the sophists get paid more than Socrates does. But in your position, your position is to write the great dissertation or book or newspaper article that will put us all straight. Get us to the if not the truth, because I mean, as you point out, the statement like freedom of expression is multivalent. It's you can ask what did Madison or Jefferson mean by free expression, but that may be of mere historical interest. If the question is what theory of freedom of expression will create the best society or the morally best society, right? That may be a very different question.
Mm-hmm. So when it comes to like morality, like the morally best society or the most just society, the most fair society, do you think of these notions in terms of like within this sort of social contract theory, or is it something else?
I don't know where you read that I am the expert on all things. I don't have the final answer about constitutional law. I don't have the final answer about freedom of expression. I certainly don't have the final answer about justice and politics. I can tell you what I'm thinking this week, but it may be different than what I think next week, and I'm not sure, given that I'm not the czar of all the Russias, why anyone cares what I'm thinking this week.
Mm-hmm. Yeah, no, I'm not, assuming anything that you had.
I mean, I had a discussion with someone recently about objectivity of morality, and I said on Mondays, Wednesdays, and Fridays I'm an objective moral realist, and on Tuesdays and Thursdays I'm an anti-realist. So I don't have settled views on these matters. Like you, I keep reading, I keep studying, and my view varies perhaps with whoever I read most recently.
Mm-hmm. Usually what I find, like as like scholars, philosophers get older, they become more conservative in their views. They're less willing to sort of change it. But if you're still changing it on a daily basis, that's probably a good thing.
I think my role as a teacher has taken primacy, that I'm on the one hand this and on the other hand that sort of view, and I don't seem to settle on any view, hyper conservative or otherwise.
Mm-hmm. That's great. So yeah, I've basically just exhausted, and even especially now that
exhausting is exactly the word.
No,
I appreciate your patience.
No, exhausted the sort of the main topics that I wanted to talk to you about, especially now that you've mentioned you said that you're not an expert on everything, and and I do understand what you mean by that, but it's comes from a place of,
and I don't claim that I am the expert on the things we talked about earlier, but everything is relative. I feel a bit more comfortable offering opinions on some of the earlier topics than the ones we're verging towards now.
Professor, thank you so much. I've learned quite a lot from you.
And you stayed awake for most of it. That's impressive.
Sorry?
You stayed awake for most of it, which as I said, most of my students won't. But
Really?
I'm honored to have had this discussion. I thank you very much for the opportunity.
Thank you so much. Thank you.